Thank you, Ms. Kraft. And welcome everyone. This is day two of our November docket for the Tennessee Court of Criminal Appeals here in Nashville. My name is Robert Wiedemeyer. My colleagues today are Judge Robert Holloway from Columbia and Judge Ross Dyer from Memphis. And we are obviously Zooming the arguments and we are anxious to get back into the courtroom, but we're also grateful to have the technology and the hard work of the clerk's office, including Ms. Kraft and Jim Hivner and Nick Morgan at the AOC, so that we've been able to hear these oral arguments on these cases through the pandemic and dispose of the cases in a timely manner. But again, we're anxious to get back into the courtroom at the earliest possible time. That being said, we'll conduct the proceeding today on this case just as if we were in court, 20 minutes per side for argument. We have read your briefs, and so you can keep that in mind as you argue your cases. I understand, Ms. Jones, you'd like to have 4 minutes of rebuttal time. Is that right?
Yes, Judge Wiedemeyer. Thank you.
Right. I'll help you keep up with your time. I think that's all the preliminaries. Ms. Kraft, if you'll call the case, please.
State of Tennessee versus Deandre Ellis.
Morning, Your Honors, and may it please the court. Kendall Stivers Jones from the Appellate Division of the Public Defender's Office, Public Defender's Conference, on behalf of the appellate, Mr. Deandre Ellis. The case before the court today is solely here on an issue of sufficiency for Mr. Ellis's jury conviction for tampering with evidence. And specifically, Mr. Ellis challenges the sufficiency of the evidence on the element of concealment. I know the court is familiar with the facts, but just briefly, the proof at trial established that Mr. Ellis placed a Glock handgun that he used to commit second-degree murder inside the toilet tank of an upstairs bathroom in a friend's nearby apartment where police located him soon after the shooting occurred. Because the police were able to track Mr. Ellis's flight from the murder via security cameras to that exact apartment, they were able to recover the Glock when they took him into custody and searched the apartment. The TBI expert testified the Glock was still in working condition when she received it and was able to be tested and used against him at trial. The surface rust on the firearm was able to be removed, and as a result, the firearm was able to be tested, and the rust that was on there, she testified, was from the packaging that the police had put the gun in for transport to the TBI. They submerged it in some of the toilet water. And the picture of the Glock as it was entered and found when the police searched the apartment was Exhibit 18. Because of these facts, Mr. Ellis argues that no rational trier of fact could have found that he did anything other than attempt to conceal his possession of the Glock rather than intend to impair the Glock's availability for evidence. As this court is familiar, the concealment, tampering is an issue of timing, action, and intent. There was no question that Mr. Ellis knew that an investigation would be or was in place. There's no question that he concealed it. So it is distinguishable from the watershed case that we cite throughout our brief of State versus Watkins, which was an abandonment of the firearm. But if Watkins told us anything, it's that these cases are very fact-intensive inquiries. And Mr. Ellis, for that reason, argues that the combination of the minimal delay in the time that it took police to recover the firearm, the fact that the weapon was able to be tested still, that the gun was placed out of sight, but that is not absolute proof of tampering, as State versus Hill that we cited in our brief tells us. And for that reason, it's clear from the facts that his intent was to hide that he had possessed the gun rather than to conceal the gun for purposes of the police never finding it or not being able to use it. Some of the cases we cited and some of the cases the state cited from Tennessee and from other jurisdictions, because Watkins examined a number of cases from other jurisdictions in order to kind of guide its analysis. This was not something that it took the police a long time to find. This was not something that they had to do a great deal of effort in order to get it. They were able to recover it sometimes, that they're never able to recover it.
So if you're bad at hiding, you get a lesser penalty?
No. And that's the thing. He wasn't bad at hiding. And that goes to the fact that just supports the argument that he intended to conceal his possession. If the police are at the apartment and coming in, they were given consent to search, they're going to find the weapon. It's just not going to be on Mr. Ellis's person. I know the state speaks to that some in its brief, and it's true that he did take the weapon with him and not dispose of it like he did the hoodie, for example, that he got rid of in the dumpster on his path to the apartment. But the weapon that he kept with him, that's not necessarily dispositive or one of the factors even that Watkins examines, or some of the other cases that we've cited in our brief. A lot of them, he was under no obligation to turn anything over to police. He didn't he could have done a lot of things. We can't analyze those.
Does it become a jury question though, then, as to what his intent is?
Well, the intent is inferred from the facts, which that would be a question, but it's whether enough. It's not so much. It's more of it's a bar. It's a height question. Do the facts reach enough that they would allow a rational trier of fact to come to the conclusion that they did? And in this case, we do not think that they did. The important thing is the distinction that the case law makes between trying to conceal the fact that I have it or the person has it versus trying to permanently or trying to impair its availability at all. He could have done a number of things along the path to the apartment. Of course, we have to consider what he actually did and not all the possibilities, but he kept it with him. There were a number of people in the apartment, as we mentioned in our brief, and as the record bears out. He could have done a number of things with it, and he just put it in the toilet tank and came downstairs. We've also cited a number of cases. A lot of them deal with marijuana and a person being detained after an arrest or after detainment, and the police having to force them to spit out marijuana, which goes to the fact that even though it was concealed or out of sight, that's not necessarily enough to bear out the analysis that it was an intent to permanently deprive or to prevent the police from using it as evidence. It's just one factor in a number of factors that are to be considered from State versus Watkins.
What was the time frame from the shooting to the time the police found the gun in the toilet?
Judge Holloway, I believe, piecing together from the footage, the timestamps on the footage, I believe it was under 2 hours, but it was very quick. This case was unique in that there were a lot of cameras in the housing area where the shooting took place and near the gas station. So they followed him in not almost real time, but they were able to track very quickly using the security cameras from the housing development where exactly he went. And the police, I don't have a time frame on the police, but the police, when they arrived at the apartment, they were eventually let in. There was some delay in being let in, and they were given verbal consent from the apartment owner to search the apartment, and they found the gun during that initial search. Unless the court has any further questions, I'll rest at this point.
Let me ask one more question.
Yes, sir.
Was there any evidence that this damage to the gun from the rust was caused by this short period of time that it was in the toilet, as opposed to the long period of time, I assume, that it was in an evidence bag with the police department?
The image, I will say, I can't say explicitly yes or no at that. I can only give you a lawyer answer and just give you the facts, and it depends. But the TBI agent testified that the surfaced rust that was on the gun was likely the result of it being packaged in the toilet water. Now, you cannot tell from the picture whether there may or may not have already been surface rust on it at the time that the police took it. So that I can't answer, but the TBI agent, Terry Arney, did testify that the rust that she was able to clean off was likely the result of being packaged in the toilet tank water.
All right. Thank you,
Yes, Judge.
Ms. Jones. General Finley? Good morning.
May it please the court, David Finley on behalf of the state. Judge Holloway, in response to your question, there's no proof that the rust formed while it was actually in the toilet. Again, but the state's position here is we look to intent. What did the defendant intend to do? What could the jury infer from what he did regarding sufficiency of the evidence? The defendant took some time to put this in the toilet and put it in a toilet full of water. And we think that in and of itself permitted the jury to find that he intended to tamper with this. And I think one way to look at this issue, if you look at Hawkins, and this will not apply to every case, but I think you might look at it from, is it a spontaneous act or did the defendant put some thought into it? And Hawkins, which is the case we both cited, the defendant's action of just throwing a shotgun down was basically a spontaneous act. In most of these marijuana and the mouth cases that the court has cited to, again, a spontaneous act. It just no thought to it, just do it. Here, the defendant kept the weapon with him for a while, a good long while, until the very last minute, when everybody in the living room fled to the upstairs bedroom. He did not join them. He went to the bathroom where he could be alone. He spent a few minutes up there. The police testified that it took him a few minutes before he would finally come down. We would submit this was a considered act. He put some thought into this, put some thought into where he was going to put it, and the jury could reasonably infer that he tried, number one, to hide it, number two, to impair its use as evidence by putting it in water, hopefully to degrade fingerprints or DNA. So we would submit that there was sufficient proof here from which a jury could infer that he was trying to impair its availability as evidence.
All right, looking at the statute, I mean, the only way I can see these facts fitting under the statute is that he intended to conceal the Glock to impair its availability as evidence.
That's correct, John. And
All right, so what if he'd have put it in the drawer? Or he'd have put it under the mattress?
Well, there's, I think, in fact, a case where the Hawkins court found that putting it under mattress evinces an intent.
So if he doesn't keep it on his person and hand it to the police when they come in, he is impairing its availability as evidence.
No, Your Honor, I think you have to look at a variety of factors here. In Hawkins, the court focused on the fact that the defendant, his goal in Hawkins was just to drop the weapon and get away. Here, I think, given the fact that the defendant kept it with him, because he knew it was a piece of evidence. It has DNA on it. He had all the shell casings left at the scene. It was evidence. He kept it with him until the very last minute, till he was cornered. And then he tried to impair its use of evidence, particularly by putting it in water. You know, we take hiding out of the equation here for a minute. He put it in water. I mean, he could have hid it in a drawer. He put it in water. He could have gone to the bedroom with everybody else, put it into a drawer. He didn't do that. He went where nobody could see him, put it in there, and the police had to search the apartment. Now, there's no proof in the record about how long the search took, but the officer testified he was asked to help in the search of the apartment. So I think the jury could reasonably infer that they had to search the whole apartment. They searched the upstairs and the downstairs. They didn't know where this weapon was. So it took some searching to find it. So from all of that, I think a reasonable jury could find that the defendant intended to hide it if he could and impair the ability to get fingerprints or DNA off of it if it was found.
Did they get DNA or fingerprints off of it?
They did not, Your Honor, but I think a reasonable jury could find that putting in water was for that purpose.
Did the evidence bag, the way I understood it, also had the toilet water in it?
It had water in it, and I don't know if it was the toilet water or not, Your Honor.
They didn't let the gun dry out. Try to get.
They did not. I think that's protocol, Your Honor. So again, yeah. But the question here is not whether he was successful; it's what he intended. And I think a jury could find that he intended to do it. He wasn't successful, but that was his intent. And if the court has no further questions, we ask you to affirm. Thank you.
All right. Thank you, General Finley. Ms. Jones, any rebuttal?
Yes, Judge Wiedemeyer. First, I'll clarify the mattress comment just to distinguish it, because this was in a residence. This wasn't the mattress case was not a mattress. If Mr. Ellis, for example, had gone into the upstairs bedroom instead of the bathroom and shoved it under the apartment owners or the renters' mattress, the mattress was full of leaves and outside behind a barn, outside in someone else's property. So this isn't a mattress in a home that we're talking about. This is an extensive search from that case. It was a Kentucky case where it had to be an extensive search in order to find the weapon. Two, I would encourage the court to look at I can't say anything about the water myself, but the water in Exhibit 18. This is not a fully submerged firearm. The Glock was placed in the toilet, but it should be evident from Exhibit 18 that this was not completely submerged in water. And to the point from the state about whether this was indicative of spontaneous act versus thought, the fact that Mr. Ellis kept the gun with him so long after he had removed his hoodie, who supposedly, I guess one could state, alter his appearance after the shooting. The fact that he kept it with him rather than discarding it at that point would go to the fact that he did not expect to encounter the police as quickly as he did, which he shoved it in a place by himself. There's no evidence that the other people in the apartment knew what he'd done. Or at least to my recollection, but that whether or not the weapon was kept with him for a long period of time and placed in the toilet, I think it's a little bit of a stretch to say that it was not a spontaneous act versus one of considered thought. Oh, and to that end, just to clarify, we would ask for this court to reverse and vacate Mr. Ellis's conviction for tampering with evidence. Thank you.
All right. Thank you, Ms. Jones. Both attorneys, the court appreciates your excellent briefs and good arguments today. We'll take the case under advisement and issue an opinion in due course. And we'll be in recess, Madam Clerk, until the next case.
This Honorable Court of Tennessee is now in recess.